Good afternoon and welcome to Division 4 of the Colorado Court of Appeals. My name is Bob Hawthorne. I'll be presiding judge over the proceedings this afternoon. We have a 1:30 and a 2:30 docket. And at 1:30 we have two cases on our docket. To my right is Judge Fox, Judge Terry Fox, and to my left is Judge Henry Nieto. We will comprise the Division 4, which will be rendering an opinion in this matter in due course. Have counsel had the opportunity to review our practice and protocol before the court, and do you have any questions about that?
Your Honor, I have had a chance to review the protocol. I noticed that the table to my left is empty,
I'm kind of noticing that myself, yes.
so I just want to make sure the court was aware. I'm not sure what's going on.
I'm not sure either. Have we heard any? I haven't heard anything. Bailiff, have we heard anything about the appellee in this case, first case?
Your Honor, if I may, is it the Edwards case that's first, or is it a different?
Sandell.
It is Sandell,
Okay, that's not me, I'm sorry.
People v. Sandell.
Sorry.
I'm-
Online, it has Edwards first.
Oh, is that right?
It does, and Your Honor, that may be because, I think the clerk has intentionally done that because I actually am set at 2:30 in the first floor courtroom. So they had told me I would go first in here.
Okay.
I'm okay if we switch the order, but
It doesn't matter if both sides are here.
Right, right. Let's see, and which case are you on?
I'm on Mr. Edwards' case.
Mr. Edwards' case,
be May.
Current calendar online has us set first, I believe.
okay.
We didn't get the current calendar.
I guess we didn't get the update. I have People versus Sandell and Edwards versus May to begin with.
Excuse me.
That's-
I'd be happy to switch
That's fine.
order as long as perhaps notice could be sent to the first floor courtroom that I might be a few minutes late.
No, that's fine. You're set up at council table, and I'm sure that council and People versus Sandell, you don't have any objection to that, do you? Switching that around? Apparently, that's the way it was showing online anyway. Okay, so let's start again here. Sir, do you have any questions about our practice or procedure here?
No, Your Honor, thank you.
All right. And let me remind you that time is self-monitoring. Appellant can reserve some time for a rebuttal if you wish to do so. If you want me to try to help you reserve some time, let me know, and I'll try to do that, but otherwise it's self-monitoring. And I'll remind you that we are now live streaming our oral arguments, so if there's anything confidential or sensitive in your arguments, please be aware of that. I would remind those in the gallery to please turn off your cell phones or any other device that you might have with you that might go off during the proceedings. We don't want to disturb counsel's arguments. And with that, counsel, we're ready to proceed on, and we're going to do Edwards v. May, case 2017CA2081.
Thank you, Your Honor. May it please the court, counsel, my name is Gail Johnson, registration number 29703, appearing on behalf of Billy Edwards, along with my co-counsel at counsel table, Hillary Eisenman. This is an appeal under the Colorado Criminal Justice Act, and I wanted to just begin by emphasizing the standard of review. The district court's review of the custodians of records' determination is for an abuse of discretion. But in a case that, in terms of appellate review of the district court's decision, in a case such as this, where there are no factual findings or credibility determinations that were made by the district court, this court's review is de novo because this court stands in the same posture vis-a-vis the district court in reviewing the custodian's determination as set forth in the Madrigal case. So I just wanted to make sure we were all on the same page with that. I'd like to begin my remarks today by emphasizing that the statute promotes disclosure and the statute promotes partial disclosure where there are legitimate interests. In other words, redactions. The statute itself talks about the duty to allow inspection of any portion of a record. And the facts here are undisputed. There are at least 8 boxes of documents in the possession of the district attorney's office that have not been provided. And in this CCJRA case, they have provided not a single page, redacted or unredacted.
Counsel, this went through a trial, 3 trials, and 2 post-trial motions. Did the district attorney provide discovery during those proceedings?
The district attorney did provide discovery to Mr. Edwards' trial counsel. That discovery is not something we could obtain from him because he no longer has it. We tried that before we went down this road. And so it is routine in this state, as we demonstrated at the show cause hearing, it is routine for post-conviction counsel to enter an appearance and make an informal request directly from a district attorney office's discovery unit. And as we demonstrated at the hearing, that routinely happens within 10 days or 2 weeks, including it has happened before in El Paso County on that time frame. It's happened in Adams, Arapahoe, Boulder, Douglas, Denver, Jefferson, Larimer, and Lincoln counties.
Counsel, I understand that you requested discovery informally. I failed to understand why formal discovery was never requested within the context of the criminal case.
Well, Your Honor, there does not appear to be a legal rule under the criminal rules of criminal procedure that provides for post-conviction discovery. And that is why, because I was informed by the custodian in his office that they would fight us if we fought, and I did not think I had a rule-based argument. So it seemed that the appropriate, and just to be clear, I see the court's hesitating or perhaps has a puzzled expression on its face. Rule 16 on its face applies to discovery pre-trial. That word is in the title, pre-trial discovery.
Then, counsel, what was your reference earlier where you say all these other counties always provide discovery? What was that a reference to?
That's true. That's the evidence in this case, and I think that's happening as a matter of culture and practice. But it's not happening as a matter of legal right. Those people are not litigating it in front of a district court. And so the district attorneys have been routinely, in other jurisdictions as well as this one, in other cases, providing discovery upon entry of appearance promptly.
That being the case, wouldn't it have been a good idea to seek discovery in the criminal case with all of its pluses and minuses to the parties? Very different than the discovery that you're seeking here. And in essence, you're still seeking discovery.
We are seeking the discovery as well as the rest of the district attorney's files. So we did seek it. We sought it.
So you're seeking their work product and everything else?
Well, Your Honor, if they want to make a work product assertion as to certain pages, they can do that, and there's a procedure where a district court would review that assertion of privilege for adequacy. But none of that process has happened here because they have 8 boxes and they haven't turned over a single page, redacted or unredacted, with any kind of privilege log. That's the state of the record. And I did, and the record is clear, I direct this court's attention to the supplemental record, which was filed on July 17th of 2018, pages 59 to 64. That's Exhibit U from the show cause hearing. I was more than eager to work out an arrangement in the criminal case if they would give me the discovery there. But what I was consistently being told is we will fight you, and that was indeed also the evidence at the show cause hearing. We don't think, both District Attorney May and his chief deputy, I believe her title is Kim Kitchen, testified that they don't believe there's a legal basis for providing discovery in a post-conviction context in a criminal case, and that they would vigorously fight that. So to get back to your question, Judge Fox, I deemed it futile, and this seemed the appropriate mechanism. Additionally, to be clear, I think the underlying premise of this argument is that somehow under the CCJRA, they can withhold documents if you have a theoretical right to get them somewhere else. That's not in the CCJRA. That's made up out of whole cloth. I mean, I think that premise is sort of flawed.
Let me ask you this. Say it wasn't counsel for Mr. Edwards that was seeking information about the proceedings, maybe one or all 3 of the cases that had proceeded to trial, because I understand there were 2 that did not result in a verdict, I believe, or?
Correct, Your Honor.
Okay. Say it was a newspaper reporter that wanted access to those records. Would they have been allowed access to any or all or parts of those files? Or should they?
You're right, that may be a different case, but I think what I want to focus the court's attention on here in this case is the pretextual nature of the excuses that were given. Because if the concern about privacy was genuine, it would have been resolved by my repeated open offers to enter into a stipulated protective order, an order entered by the court, either under the CR case number or in the CV case number. But they didn't ever want to do that because they want to keep withholding the entire 8 boxes. Again, and if we can get back to, there's perhaps assertions of privacy here, but I think it begs credulity to think that every single word on every single page of 8 boxes of documents raises a privacy concern.
You may proceed.
And I would direct the court's attention on the redaction issue and the duty to make partial disclosures. I direct the court's attention to footnote 3 in Freedom, Colorado, which really addresses that in detail. It says, a custodian should redact sparingly to promote the CCJRA's preference for public disclosure. And specifically that the custodian, the court's supposed to decide if the custodian has properly determined one of 3 things, the second of which is to allow inspection of a redacted version of the record at issue. So I know we've addressed at length, and it's very factually detailed in our briefs about the pretextual nature of some of these excuses, but the fact that they shift over time, the fact that they are implausible on their face, for example, we won't give you the discovery to my co-counsel because you're not lead chair. I think this court can find that that's implausible on its face. The fact that they have this supposed newfound concern about privacy that didn't exist 20 years ago when these events were fresh. None of that, all of those factors, and including the absolute falsity of one of their assertions, namely that there's an ongoing criminal justice investigation. Ms. Kitchen testified at the show cause hearing, this investigation is closed, we deem it closed. That's true, even though there were 2 shooters and they've only ever brought Mr. Edwards to trial.
So am I correct in understanding that not a single page of documents has been produced in response to the CCJR request? Is that correct?
100% correct. Not a single page, not redacted, not unredacted. If I may save my remaining time for rebuttal. Thank you.
You may.
Thank you, counsel.
May it please the court, Stephen Klasky, attorney registration number 44836, on behalf of Daniel May, the custodian of records. Good afternoon, Your Honors. I would like to briefly address, I agree with my colleague to my right that the standard of review is properly captured here today. I would note, however, that I do believe that this court sitting de novo is reviewing the trial court's decision to see if the trial court properly held the custodian to the abuse of discretion standard. And Your Honors, I would point out that there was lengthy testimony at the trial court level where the Honorable Judge Kane of the 4th Judicial District heard testimony from the district attorney, who is the custodian of record, Kim Kitchen, who is the assistant district attorney who also assists Mr. May in CCJRA requests, as well as 2 other witnesses that were called.
Counsel, if we find that the custodian of record, in fact, misapplied the law in disallowing disclosure of any single document that was part of this file, can't we say that there was an abuse of discretion?
Your Honor, absolutely, I think you can. I would suggest...
Why shouldn't we?
Well, yeah, thank you, Your Honor. As we all know here today, there are 2 cases that deal with the 5 factors that custodians have to balance. It's the Harris and Freedom, Colorado cases, and then Madrigal, of course. And Your Honors, I would like to just briefly pull out some of the things that were discussed, which shows that the custodian did not abuse his discretion. For instance, Your Honors, Kim Kitchen, when she testified, the assistant district attorney, said that she considered privacy interests of victims, witnesses, jurors, that these files were covered with dates of birth, medical information, social security numbers, and attorney-client work product. And I remind this court that this was back in the 90s, so these case files, yes, there's 8 or 9 banker's boxes of these files. Certain protections of information may not have existed back then that they do today. So Ms. Kitchen also testified that when they had gotten records from Penrose Hospital, for instance, they just sent over, Penrose being they, these records without any redactions to any of these medical type information, so they have all of this.
But counsel, couldn't
Yes,
those
sir.
concerns that Ms. Kitchen was expressing, couldn't they have been handled by redacting at this stage, rather than depending on redaction of the documents 20 years ago?
Your Honor, yes, I think they could. However, I would suggest to the court that the original CCJRA request, which is Exhibit G to the trial court's record, requested a complete copy and the entire contents of your case file, including but not limited to all discovery that was disclosed to defense counsel throughout the course of the case.
But can't we consider Mr. Edwards' counsel's subsequent letter offering to submit to a protective order or offering to accept redacted documents, a modification of that?
Your Honor, I think redacted documents, certainly. Protective order in this context, I don't know that that's necessarily applicable in a CCJRA application. A CCJRA application, I think Judge Fox, as you properly pointed out, this is dissemination to the public. This is not a special discovery for a particular person. Our view is that this is, when someone comes in and makes a CCJR request, that information is then presumed to go out to the entire public for public consumption.
But why should Mr. Edwards' counsel have access to less information than a member of the public or a member of the press would have access to?
Your Honor, while it's not in the record, I think I'm safe to say that my contention would be if a member of the press asked for that exact same thing, they would be getting the same response from the custodian, a denial.
They would, even though there were 3 public trials at which a lot of this information was made public already.
Your Honor, again, I think it would depend on the specifics of the case, but if for instance, so in the other cases in Harris and Freedom and Madrigal, to a lesser extent, you do have the press asking for information, and they are asking for very specific points and likely talking about redactions and things of that nature. In the actual record, there was elicited a response about redaction one time, and Ms. Johnson did ask in the transcript on page 53, lines 23 through 25, you haven't redacted a single thing, have you? And the answer was no, but there was never anything else on the record to suggest we, being the requesters, came to you and asked, can we get these redacted files? And you have to look at the context, I suggest, that they are trying to get the entire case file to pursue post-conviction relief. What the custodian is saying is, take that into your criminal case. We're really looking at 2 separate things here. You have your post-conviction case, which is the Rule 35C, and then you have a CCJRA request. And we're sort of mingling the 2 together, and I would suggest that that mingling isn't necessarily appropriate in a balancing test for the custodian who looks at a record request on its face, conducts the balancing test, and then renders a decision.
But
Why isn't
Mr. Edwards' counsel ended up resorting to this statute because she was denied access to that information in the criminal case. I mean, what's the legitimate basis to not grant his counsel access to the case files?
Your Honor, and I think as you also asked earlier, these were informal requests. So what the custodian is saying is take this to the presiding judge. We both have, meaning the district attorney and counsel for Mr. Edwards, has the right to present these arguments with related directly to discovery before Judge Bain of that court. He's saying that let the judge make that determination. Just because we, the custodian, are saying we will not fight you, but we will oppose it, that doesn't mean that they still may not get it. I mean, that's putting the discretion into the judge's hands in the criminal case.
But, you know, Judge Bain, and granted, this happened after the record request under the CCJR was initiated. I mean, once Judge Bain on October 6, 2016 issued his order, effectively recognizing that they were properly acting as counsel for Mr. Edwards, again, what legal basis was there to deny them access to the files?
Your Honor, again, I think that's going back to the discovery case related directly to the CCJRA case before us, which is the balancing test. And Judge Bain, I would note, because there is some discussion of this in both briefs, that there was an attempt of stonewalling or something like that. If you go back and read Judge Bain's orders, I would suggest that it's anything but stonewalling. I would suggest that Judge Bain also recognized that there was a legitimate question raised by the district attorney in that filing.
So, and I think either you or somebody on your side of the case filed a notice of related case. And I guess Ms. May did on August 19, 2016. And she specifically represents that the status of representation in 97CR231, the criminal case, affect counsel's entitlement to the record sought in this manner. So why shouldn't we take that as effectively admitting that if the court accepted that they were acting properly on behalf of Mr. Edwards, they were entitled to access to the files?
And Judge, I don't disagree with you. I just think that that's a separate issue. That's an issue before the criminal court, not an issue before this court today in this civil CCJRA appeal. I would also suggest that all of this came up at the trial court, and the trial court still recognized that there was, in the trial court's ruling, that there was not an abuse of discretion. And at one point, I think the trial court even wanted to kind of reel the hearing back in. On the transcript on page 81, lines 2 through 28, Judge Kane says he does not want to retry the merits of the Rule 35Cs or the underlying conviction, and he recognized that the abuse of discretion was the proper standard. So to get to your point, that factor alone was not, there was no single factor out there that caused the custodian to deny the request. Again, it was looking at every single factor as he's required by law to do and balancing that. And I would suggest to the court that the record is replete with evidence to show that the custodian did indeed balance all of those factors, went through and talked with his assistant district attorney. His assistant district attorney even reached out to CDAC, which I believe stands for Colorado District Attorneys Council, and asked her colleagues some of these same questions. So there was a lot of thought.
And is that part of our record?
Yes. And so there, and Judge, for the record, that's on page 25 of the transcript, lines 1 through 14. And so what our base issue here is we feel like there are two separate things going on. You're having a discovery issue, and I think, Judge Fox, you asked a great question of why haven't you pursued that with the criminal court? And I understand that there is a reading or an understanding that maybe Criminal Rule 16 does not apply to post-conviction, but they haven't raised that issue with the judge. And there's nothing in the statute, the CCJRA, any case law interpreting it, or the legislative declaration that suggests the CCJRA is meant as a discovery tool or a discovery mechanism. So when we talk about the frustrations of getting discovery, our position is really that is in the criminal case, not in this matter before us today. And Judge, I would also state here that the public purpose served, which is a major factor here, there are several references throughout the trial court testimony where both Dan May and Kim Kitchen said they went through the letters that were sent to them, the requests, and they pulled out the statute, as they always do, and they go through every factor and they make that determination. And I think, Your Honors, if you review the trial transcript, you'll see just that. And unless there's other questions, I would ask to reserve my time.
There is no time to be reserved by
Oh,
the
sorry.
appellee. So you either use it now or you're done.
Thank you, sir. I apologize for that.
Let me ask you a question.
Sure,
Is there-
absolutely.
Is there anything in the CCJRA or in case law that prohibits having discovery procedures proceed in the criminal case at the same time a request is being made for records from the district attorney's office under CCJRA?
Not to my knowledge, Your Honor, and that rings true with Cora as well, that they can still come in. And again, I think that reinforces our notion that CCJRA and Cora, to a lesser extent, are separate mechanisms to request records. You often see cases of the media, right, asking for these records. You don't often see someone who is filing a post-conviction appeal using the CCJRA as their purported
Well, you don't.
primary.
I agree. Excuse me, I didn't mean to interrupt
No,
you.
sorry, please.
You don't often see that, but is there anything that prevents that?
I don't think there's anything that prevents that, but there's one other thing that I wanted to point out. That's in CRS 2472-306, that is the CCJRA, the copies, printouts, and fees. Under subsection 3, because we're talking about when you do redactions, when you do review, the custodian gets to charge time to go through and do that. In subsection 3, it says the provisions of this section shall not apply to discovery materials that a criminal justice agency is required to provide in a criminal case pursuant to Rule 16 of the Colorado Rules of Criminal Procedure. So in other words, I think there was some thought about that. If the DA or anyone has to give records under Rule 16, they don't get to charge for it. But if it's coming in as a pure CCJRA request, they do have the statutory right to charge time for that too.
Yeah, but they didn't say, fine, we'll give you the records, but we're going to charge you for them. I mean, that was not offered as an option.
The record does not support that, Your Honor. And then lastly, in my last 30 seconds, pretext. I am concerned that potentially the appellant is bringing up a pretext standard, and this is in our brief, as an overlay of some sort of other type of standard of review to use. I would suggest that the pretext cases that were cited are in the employment discrimination context or striking of racial minority jurors. It does not have anything to do with the CCJRA. Thank you.
Thank you, counsel.
Counsel, would you begin by addressing one of his last comments about what interplay there is between the CCJRA and Rule 16 of the criminal rules?
I'd be happy to, Your Honor. Again, Rule 16 on its face applies by title to pretrial discovery only. And I'm not sure that this case was cited in our briefs, but I direct the court's attention to People v. Owens, 330 P. 3rd, 1027, Colorado Supreme Court, 2014, specifically around paragraphs 12 through 15. That's a case where, in the context of a capital cases, the Colorado Supreme Court said Rule 16 discovery does not apply in the post-conviction capital context. Now, one could, I suppose, distinguish that and say this is not a capital case, but the reasoning there is not distinguishable. The reasoning there is based on the plain text of the rule and that it governs pretrial discovery only. And the Colorado Supreme Court sort of said in Owens, this doesn't just mean that it's ongoing forever, the duty for pretrial discovery under Rule 16. And even today, we do not hear my friend across the aisle saying, we agree that Rule 16 governs this and discovery can be provided under Rule 16. That's not what they've ever said, and that's not what they're saying today.
Do you think in the criminal context that if you're denied discovery under Rule 16, that you could then come under the Criminal Justice Records Act to get asked for the same thing because of a different standard?
Your Honor, I don't think that's a necessary predicate to a CCJRA request. There's nothing in the statute that suggests that. There's nothing in the case law that suggests that. And again, counsel for the custodian has never cited any authority for such a proposition.
I don't think
And
you understood my question.
I'm sorry.
If the defense is denied discovery under Rule 16, Can they then turn around and say, okay, we want the discovery under the CCJRA because it's a different standard under CCJRA? It says everything, where the Rule 16 has limitations on what you can get.
I think I'm understanding the court's question correctly. If we were denied by a court, Rule 16 discovery in the criminal case, does that somehow preclude us from asking for it under the CCJRA? Is that
Yes.
did I understand that? Okay.
Well, I didn't state it in that way, but yeah, are you precluded from doing it, or can you do it?
I don't think we're precluded. I'm not aware of anything that would preclude us. Because it's not that it would be a different matter. Let me clarify. It would be a different matter if Rule 16 of the Colorado Rules of Criminal Procedure generally said you can have discovery in a post-conviction context, but here we don't think this particular set of documents is discoverable under the rule. That might be a different issue, but that's not what we have here. What we have here is, I believe, Rule 16 as it exists is simply not the right vehicle. CCJRA is the right vehicle. And although it's not precedent, I would also direct this court, it's not precedent for this point. I would direct the court's attention to the Foster versus Chapman case we cited in the briefs. That's the U.S. Supreme Court's Batson decision in 2016. The site is 136 SCT 1737. Again, that's a Batson case, but the factual basis for the Batson claim in that case was actually documents that were arguably work product from a prosecutor's files that were produced under Georgia's open records request. So I just bring that up as an example of, certainly there's precedent for the concept that you get post-conviction documents through open records, states' open records statutes. I see my time is running down. If I could just make a couple other quick points. The duty to redact is self-executing. I can't tell them what to redact because I don't have the documents. It's clear that the duty is on the custodian to make the redactions. That's clear under the statute, and that's clear under the Freedom Colorado language, and again, footnote 3. I did review quickly the brief portion of testimony where Ms. Kitchen referenced her consulting with the board of the Colorado District Attorney's Council. This court can review it itself, but it's just very, very vague. What the evidence is at the hearing is we put on 2 different credible witnesses who were subject to cross-examination who said, we've gotten this discovery just by entering an appearance in a post-conviction context in all those jurisdictions I've mentioned, including El Paso County. The custodian had the opportunity to present rebuttal evidence had they wanted to do so at the show cause hearing. They did not present any rebuttal evidence or witnesses or testimony, so that stands unrebutted in the record.
Counselor, aren't there other bases for discovery beyond the rule? Exculpatory evidence has to be discovered, period, by constitutional rule. Wouldn't that give you some basis for seeking discovery, even though the rule does not? Post-conviction?
There may be a constitutional basis, but again, I want to emphasize one of the main things we are seeking here is the basic criminal trial discovery the trial counsel had that's routinely given to defense counsel in every criminal case in this state so that we can do our jobs as post-conviction counsel to understand the witnesses' statements before we go interview them. I mean, that is all we are asking for here. This is an old case. This is an important case. It has not been handled well in the past. Unfortunately for Mr. Edwards, he has had some counsel who have had some major problems, and I know the court's aware of those. It is important to get it right, and it is important for us to have the documents to do our job. And I would also respectfully encourage the court to publish its decision in this case because there is such a dearth of case law in this area of CCJRA. It's not litigated that often, and I think that could be helpful.
Let me ask you this, sort of the converse of the question I asked your opponent, which is once Judge Bain issued his order in October 6th of 2016, making it clear that he recognized that you were acting appropriately for Mr. Edwards, wouldn't that have been the time to go ask him for discovery?
Well, again, Your Honor, I'm not aware of what rule I could have invoked because Rule 16 is the discovery rule and it only applies pre-trial. And I knew, again, that they would vigorously oppose me and I thought their opposition would be valid because
What about a constitutional basis?
Again, the Constitution is limited. It doesn't give you all the discovery. And we really need all the discovery to do our job as well as the other portions of the file. I see my time is run. Thank you.
Thank you, counsel. And the court thanks both counsel for your excellent arguments. And those arguments are going to be helpful to the division in making a decision. So the matter will now stand submitted, and an opinion will issue in due course. Thank you very much. Counsel are excused, and as soon as counsel has cleared the tables, counsel for the next case may set up. Good afternoon, counsel. Our next case on our 130 docket then is People versus Sandell, 2017 CA 200. I see counsel are set up. Do counsel have any questions before we proceed?
No, thank you.
All right, I'll just quickly, I know you were here before when we made some opening remarks, but we are live streaming, so keep that in mind. Self-monitoring on the time, and you can reserve rebuttal, appellant. And I'll remind anybody that just came into the courtroom, if there is anyone, to make sure that your telephones are off and any other device that may go off during the proceedings. With that, we're ready to proceed on case number 2017 CA 200.
Good afternoon, and may it please the court. My name is Eric Klein, attorney registration number 42185, and I represent Mr. Monroe Sandell in this criminal appeal. Ms. Johnson is a fair amount taller than me, so if I could have a second. I would like to focus my argument today on the first issue raised in our briefs, which is whether a robbery occurred under Colorado law when the force used was not prior to or contemporaneous with the taking. Time permitting, I would also like to address prosecutorial misconduct, but I definitely do want to reserve some time for rebuttal, and I will monitor my time. In this case, there's no question that Mr. Sandell did commit a theft, and he did commit a menacing, and he was convicted of both of those. There is no question that he took items from a Safeway, that he ran out of the store, and then outside the store, he was confronted by two store employees, and that then outside the store, the two store employees asked if he was going to give the items back. And there is no question that that is the first time that force was used. And the state appears to agree with all of these facts. Page 1 of their answer brief agrees with the facts as I've just laid them out. And so the question then is, was the force used to take something from the person or presence of another as required for robbery under Colorado law? Or was the force used to keep or retain something? And if so, is that sufficient for a robbery? And Your Honor, this is a question, Your Honors, this is a question of statutory interpretation. And the first step is to look at the plain language of the statute. And under our robbery statute, which is a requirement for aggravated robbery, is that there was a robbery in the first instance. Under our robbery statute, there's no robbery unless the force used, there's no robbery if the force used was only after the taking, because our statute says a robbery is a person who knowingly takes anything of value from the person or presence of another by use of force, and so on.
But what in that language gives you the timing that you're arguing for? I mean, I don't see anything that either requires contemporaneous with, requires before, requires after.
Well, I think there's a couple of things. One, I think the way that Bartoszewski, that our Supreme Court interpreted the statute in Bartoszewski, is that the application of physical force or intimidation against the victim occurred at any time during the course of a transaction culminating in the taking. And so the question is then, what is the taking? And when is the taking complete? And I think that's where really a comparison between the robbery statute and the aggravated robbery statute, as well as between our robbery statute, which is a common law robbery statute, and model penal code robbery statutes, that's where those really, I think, demonstrate when the taking occurs. Because under our aggravated robbery statute, there's a distinction between the robbery and immediate flight therefrom. And if the taking extended during this whole time, as the People versus Fox, and I'm going to refer to it as that such, so I'm not just saying Fox is wrong. In
Thank you
People
for the
versus Fox,
clarification.
what I think that's wrong is that the force occurred during what would be flight, when the person left the store, was trying to get away, and was accosted, for lack of a better word, by the victim's husband. Well, if that's all part of this continuous taking, then there's no purpose for the immediate flight therefrom language in the aggravated robbery statute, and that would then be surplusage. And under our canons of statutory interpretation, the court should read a statute so as to avoid surplusage.
Mr. Klein, let me ask you, you just a few sentences ago mentioned Bartoszewski and some language from Bartoszewski, but how do you reconcile the additional language from Bartoszewski that there's no requirement that the application of force or intimidation must be virtually contemporaneous with the taking? How do you reconcile that with your timing argument that you're making?
Because of the facts of Bartoszewski. Bartoszewski was a horrific felony murder case where a 8-year-old girl was slain as a drunken man went into a house to steal firearms. And the question was her slaying sufficiently removed prior to accessing the firearms that the force wasn't used to obtain the firearms. And so the question in Bartoszewski was that so far removed prior to the taking that it would not be a use of force contemporaneous with the taking. And so Bartoszewski really looked at it and said, well, here, and if the court reviews Bartoszewski, and I'd point to pages 244 to 45, really talks all about prior to. The words before and prior to are used repeatedly, and that's because the question is whether the taking was accomplished by the use of force, right? There's an actual quote, page 244, the taking of the property was accomplished by the use of force. And so that's different from keeping or retaining. Now, Bartoszewski was not addressing this issue. Bartoszewski was addressing only force prior to, but the discussion is that it was basically the force is what enabled the taking.
So under your theory, when did the taking occur in this case?
I think at latest when Mr. Sandell left the store, but probably while he was still in the store. He could have been convicted of theft while still in the store and removing the property. In the Osland case that we talk about, which was about a defense of property, the division of this court said, we conclude that the theft was completed when the decedent there not only exercised control of the property, but moved it away from an area within defendant's control.
What about the later act of the defendant in taking the cart from one of the two men who were stopping him or attempting to stop him, and then pulling a knife and brandishing that knife? Did that constitute a taking, or was it an additional taking, or a continuation of the taking, or how does that fit in?
Well, that's where I would argue that the taking's complete, and that's not, there can't be, this wouldn't happen, but if I were to pull out a gun right now and say, Your Honor, give me your wallet, and I get your wallet and I run out, and Your Honor runs after me and grabs me, and I say, no, I meant it, I'm taking your wallet, that's one robbery, not two. And so here, just where the taking is complete, because there is a later contact, it doesn't make it then a new taking. And really, I think that, the Osland case, again, it's a defense of property case, so it's a different scenario, but it talks about, discouraging self-help, right, that in that situation. So I think that once the taking is complete, there's not a robbery. Now, certainly there's a menacing here. And that's when the cart is grabbed or the two men approach him and there's a knife pulled, there's a menacing or two here. I'm not up here arguing Mr. Sandell is innocent of any crime, but there's a certain important distinction between a menacing and a theft versus an aggravated robbery that results in a 26-year prison sentence.
Isn't your argument blurring the distinction between crimes against property and crimes against person that discussed in Borghese? The gravamen of this crime is the assaultive behavior against the people during the course of the theft. And that occurs, whether it occurs inside the store, at the door of the store, outside the store. You still have property that those people have a right to control and own, and the assaultive behavior. Isn't that what the statute's intended to prevent?
Well, I think the statute is intended to prevent a forcible taking. So I agree with Your Honor that it's directed at protecting the person, but it's combining the taking of something of value with that assaultive behavior. And so here, the taking of something of value occurred prior to the assaultive behavior. And so what we have is the flip of the Bartoszewski case, where the assaultive behavior took place prior to the taking. And so it wasn't, the assaultive behavior did not enable the taking. It may have enabled the getting away, and that's a different question.
Once the store director and the department manager said, give us our property back, isn't that continuous taking? I mean, do they lose the right to demand the return of their property as soon as it goes out the front door?
There's a difference between, I think the key words in the court basically quoted what they said was, give us our property back. That acknowledges that the property has been taken. If those two gentlemen ran up and hit Mr. Sandell on the head with a baseball bat, or I think that they would not, certainly under the logic of the Osland decision, have the right to assert a defense of property because the taking had been completed at that point. The theft was complete. There was not force used, so it was not a robbery. They could go up and say, give us our property back, and if Mr. Sandell just kept on running away, it would have been a theft at that point. And that's all that it could have been. If they said, give us our property back, and he kept running, there would have been a theft. By pulling out the knife at that point, it doesn't convert that theft into a robbery because the taking's done. It makes it a theft and a menacing. And I think that that's also where, if the court looks at the Model Penal Code statutes, those are very different because the Model Penal Code, unlike our common law-based statute, incorporated flight after the taking. In the definition of, and there the Model Penal Code defines it in theft terms, and it's force during the course of committing a theft, and course of committing a theft includes explicitly under the Model Penal Code statutes an attempt to commit theft or in flight after the attempt or commission. I have 4 minutes and 22 seconds left. I would like to reserve those for rebuttal, if I may.
You may, counsel. Thank you.
May it please the court. Elizabeth Ford Milani, registration number 48843 for the people. With the exception of vacating the possession of the illegal weapon count, this court should affirm the judgment of conviction. I would like to go right into the sufficiency of the evidence with regard to the aggravated robbery counts, if I could. I think the key distinction between my friend's brief and mine is the difference in what is a taking. In Bartoszewski, the Supreme Court explained that a taking is a broader course of conduct, and that's where this course of transaction theory came from, not necessarily just one discrete moment when the defendant first lays his hands on an item. And this course of transaction theory has been talked about by this court subsequently. The Fox case, for instance, not Your Honor, of course, talked about how the taking was still ongoing when the defendant in that case and the husband of the victim, whose purse had been stolen, were in the parking lot. The taking was still continuing. And I think that that case can be perfectly applied here. When defendant was in the parking lot with the cart and when the two Safeway employees ran out after him, the taking was still ongoing because it was this course of conduct, this course of transaction. Subsequently, the Buell case, which is cited in the briefs, Similar idea there. When the defendant uses the force or intimidation to retain control, it's part of this course of transaction. The Foster case, that's the bed skirt case, again, a security officer in a parking lot. The Jones case, that involved gun and money, or a shooting and theft of money in a car. The shooting was actually after the defendant had obtained the money in that case. And also the Villalobos case, similarly. Those cases all stand for the proposition that there need not be this sort of very set out, rote order of events in order for an aggravated robbery to occur. As Your Honor, Judge Nieto put it, the gravamen is this taking by force, intimidation, or threat, but the taking is not this discrete moment in time. With regard to the person or presence element, those were also satisfied for purposes of both convictions in this case. Again, Bartoszewski is really helpful here. Property is taken from the presence of another when it is so within the victim's inspection, reach, or observation that he would be able to retain control of the property but for the force, threats, or intimidation. That's exactly what happened here. The Safeway employees talked about how when defendant brandished the knife, they backed up. One of the employees, SW, had his hand on the cart. He was so close to the stolen property. And but for defendant brandishing that knife, they would have been able to, the jury could have concluded that they would have been able to take those into retain control of those items. To the extent that this court follows the Benton formulation, because the employees were not touching or exercising control over the items at the time they were removed from the store, I think the result is the same. By virtue of their employment, the jury could have concluded that they had the right to exercise control over the groceries. And that makes sense. If an item falls in a grocery store, it seems perfectly proper for an employee of the grocery store to pick it up and put it back, to exercise control over that item.
Can you address your opponent's attempt to distinguish Bartoszewski as, because the force or threat happened before the taking?
Right. I don't think that that case stood for the proposition that it must occur before the taking. In that case, they talked about there was circumstantial evidence, for instance, defensive wounds on the victim that suggested the force happened before the taking. But again, that case came back to this idea that the taking was not just the moment that defendant picked up the guns in the upstairs while the victim was downstairs. There had to be this entire course of transaction for the taking to occur. So I disagree that Bartoszewski should be read so narrowly, and I think that other cases since then, the four that I cited in my brief, have, I suppose, implicitly rejected such a view. I would like to talk about, if there are no other questions with regard to Bartoszewski and the sufficiency issue, I would like to briefly touch on prosecutorial misconduct in this case, that there simply was none. This court and the Supreme Court has explained time and again that context matters with regard to prosecutorial misconduct, and that in order to determine if comments were improper, you have to look at the totality of what was said with regard and in regard to what the evidence was presented in this case. In this case, defense counsel before rebuttal talked about pretty much the same argument that we're talking about here today, that robbery couldn't have occurred because the force occurred after defendant left the store, according to the defense after the taking occurred. The prosecutor clarified that's not what robbery is. Look at the instructions. Don't be confused by that argument. This wasn't directed at opposing counsel in a disparaging way. I think that's clear from the context. Instead, the prosecutor was just encouraging the jury to go back to the instructions, look at the language. The language is clear. If the items were in their presence and by those threats and intimidation it's taken from them, that is aggravated robbery. With regard to the duty comment, again, context matters. This comment wasn't divorced from any other, let me rephrase, the prosecutor wasn't encouraging the jury that they have a duty to convict defendant independent of any other factor. That is, the prosecutor wasn't saying, by virtue of you being here and the defendant being here, you have a duty to convict. The prosecutor talked about the evidence and talked about the law, and based on that, the jury had a duty to convict. That is, the evidence showed that defendant was guilty. Even if this court discerns error, it was not plain. These were brief comments over the course of an otherwise, I think it was a 2-day trial plus the 3rd day for argument. So if the court has any further questions, I'd be happy to answer. encourage the court to affirm the judgment of conviction in this case.
Thank you. I'd like to first address Judge Fox's question about Bartoszewski and why I think that actually Bartoszewski, I don't even think I'm distinguishing, I'm relying on Bartoszewski because I think Bartoszewski supports our position. Bartoszewski, as I said, talks about the course of the transaction culminating in the taking. Bartoszewski goes on at page 245 to note in that case why the evidence supported a robbery, even though there may have been a time period between the actual force used and the taking. And the court said, the evidence, as previously noted, indicates that the defendant entered the Talbot house to steal guns, that the victim was in his path and awake prior to the attack, and the attack occurred sometime prior to the taking. And so that happening in that order was very important to the court in Bartoszewski because it was the force enabling the taking. And that's what we don't have, where there's a taking and then there's a force enabling and maybe a getaway, an escape. But that's why we have a aggravated robbery statute that makes a distinction, and that's why we have a common law statute that's distinct from a model penal code statute. The state's argument that, well, this is an ongoing offense because it's an ongoing taking, it really knows no bounds. If the store manager followed Mr. Sandell out of the store, and as he was instructed by his job to keep a safe distance and not to do anything, he keeps a safe distance. And Mr. Sandell got in a car, and the store manager says, well, I want to see where he's going. So he gets in a car and follows him. And Mr. Sandell drives to Grand Junction, and the store manager follows him to Grand Junction. And then Mr. Sandell gets out and goes into an apartment. The store manager follows him up there, knocks on the door, and says, hey, you can give that back? And Mr. Sandell pulled a knife at that point. That's not a robbery at that point. The taking is long complete. He's traveled hundreds of miles, but that's by the rationale, as long as there's some line of sight or some following somebody, that's still a taking. But then, well, when is the flight from the taking? When would the flight be? And if this is all one long robbery, then we have an aggravated robbery statute that makes no sense. And I'd say I think that the Jones and the Villalobos cases really do show that, well, there are situations where the taking might not happen. And this is why in our reply brief, we tried to respond that our argument is not as soon as Mr. Sandell picked up those items, the taking was complete. And I think, Judge Nieto, you asked a good question. When is the taking complete? And I think that in some cases it might be a finer line. And so that's why in Jones really is not saying that the force can be after the taking. What Jones is saying, in reliance on the Bartoszewski case, is that the taking wasn't complete until these guys got out of this car. And so Villalobos and Jones both are fake either gun or drug deals in a car. And so that's a very different context where, the defendants in those cases took someone's money in a fake deal voluntarily because it was a fake drug deal or a fake gun deal. But they're not able to accomplish that actual taking, securing the money, until they get out of that car, use the force. That's why those are very different. That's why Jones really talks about this not as retaining property, as Buell did, but as accomplishing the taking. That's where there's going to be jury questions on, well, what is the taking? But I submit in this case, here we have, as the state argues repeatedly, a retaining, a keeping of property, which is different than the taking. Now, in my last 20 seconds, I do just want to touch on prosecutorial misconduct because the way the state attempts to spin this argument is not what the prosecutor said. In a very brief rebuttal argument, mere 5 transcript pages, 4 accusations that defense counsel or the defense is trying to confuse the jury. These are ad hominem attacks, not in any way brought on by the defense based on a perfectly legitimate argument that the prosecution had not proven the elements. I am out of time, so I ask that the court reverse, based on sufficiency, the 2 counts of aggravated robbery as well as the weapons charge. Thank you.
Thank you, counsel. And the division thanks both counsel for your very helpful arguments. And those arguments are going to be helpful to the division in reaching a decision. So the matter will now stand submitted, and an opinion will issue in due course. Thank you very much. Counsel are excused. Go ahead and get set up, counsel, when you're ready. Let's see, on our 2:30 docket, we have a case matter of Henderson, case 17CA2223. First case on the 2:30 docket. Good afternoon, counsel.
Good afternoon.
Any questions from anyone before we proceed on our practice procedure? Okay, welcome to Division 4. I know we have some new people that came into the courtroom for this case. I just want to remind you to please turn off telephones or any other devices that you might have with you that might go off during the proceedings. And again, counsel that have just set up, I'll remind you that we are live streaming our oral arguments these days. So if there's anything sensitive or confidential in these arguments, you want to take that into account. For appellant, the timing for saving time for rebuttal is self-monitoring. And with that, unless you have any other questions, we're ready to proceed on the matter of Henderson in case number 17CA2223.
Thank you, Your Honor, and may it please the court. My name is Christina Gomez, bar number 36026, representing the petitioner Maurice Rennemeyer in this conservatorship action. Mr. Rennemeyer did what his attorney advised and what any family member faced with concerns about potential exploitation should do. He sought protection from the court. But the court didn't provide protection or even review his aunt's situation. Instead, it not only dismissed his petitions, but sanctioned him for raising his concerns at all. I want to highlight 3 critical errors in the trial court's decision. First, it failed to hold the evidentiary hearing required by statute. Second, it precluded critical discovery by refusing to allow either a psychological evaluation of his aunt or discovery from her purported power of attorney, Ms. Bradfield. And third, it never considered the fundamental, properly pled questions of whether Ms. Bradfield was properly acting as a power of attorney under a valid document, and whether there was cause to appoint a conservator notwithstanding the existence of a POA. Those decisions are legally wrong. They also set a terrible precedent that would deter people in Mr. Rennemeyer's position from coming to court with concerns about potential exploitation of elderly relatives or friends, so he asked this court to reverse. So on the first issue here about the failure to hold a hearing, nobody in the case has disputed that the statute, CRS 1514-406, requires a hearing. The response to that has essentially been, well, he dismissed or withdrew his petitions to appoint a conservator. That's inaccurate, as we've explained in our briefing. Mr. Rennemeyer withdrew his nomination of himself as a conservator and said at the proceeding before the court that what he wanted, instead of having himself take action as conservator because there was so much animosity and objections to him, he at that point thought it should be a third party, basically a neutral fiduciary in that position. At the same time, he made very clear he thought a conservator still was needed, and he was ready to proceed with evidence that would indicate that a conservator was necessary. And he asked the court essentially to bifurcate the proceeding and say, Right now, let's look at the questions of whether or not a conservator is needed, and then you can address the issue of who that should be serving, whether it be Ms. Bradfield per her request or a neutral fiduciary per his request. I'll add a couple of additional points on this thing here. First of all, the section of the statute that deals with the visitor's report, that's 1514-406 subsection 4, indicates that the visitor should interview the proposed conservator, if any, indicating that a petition doesn't necessarily have to provide the name of a specific conservator. In addition, it's clear just from reading the transcript of the proceedings before the court that it was not dismissing on the basis of a conservatorship petition that had supposedly been withdrawn. The court purported to make findings that the petition was without basis in law or fact, and that the POA was sufficient to protect the respondent. Those are findings that were completely inappropriate in the absence of a hearing. If indeed the petition had simply been withdrawn, then the petitioner could have just submitted another petition, which subsequently he did. But in this case, the court said, I'm still finding that it's completely inappropriate. Fundamentally then, because the court didn't hold a hearing and didn't take in evidence or review any of this on the merits, there was no decision on the critical questions regarding the POA, but just more generally, there was no evidence presented and no findings of the critical issue of capacity here at 3 different points in time. I mean, one was, did Dr. Henderson have capacity to sign the POA, which she signed only less than a year before these proceedings started, before the court visitor basically said she's disoriented, it's a time or place, she can't handle her own finances, and only a year and a half before the deposition where she similarly seemed very confused and unable to handle her own finances. Second, capacity at the time that these proceedings occurred here and whether or not she could even direct her own attorney. Obviously, she never herself came to court. Her counsel indicated right before the hearing date that she could have come, but because previously she'd been excused, he wasn't going to bring her into court and didn't even want her deposition submitted. So there was no evidence that the court looked at or reviewed to see, did she have capacity to direct her counsel? And fundamentally, the question posed in the petitions for conservatorship were, could she handle her own finances without having a conservatorship to look over and make sure whether the POA was still in place or the POA was taken out of place, make sure that everything was being handled, especially in terms of the inheritance, but kind of more generally.
Counsel, is there any indication in the record about why the trial would or did, in fact, give so much weight to the visitor report?
There's nothing at all in the record.
I'm assuming he was not subject to cross-examination.
That's right, that's right. And I mean, the statutory provisions regarding the visitor's report just indicate they're supposed to make these interviews and provide information to the court. You're right. I mean, not in the presence of other, like the petitioner, for instance, would not have sat in on those. So there's really, I've never even seen a case that's indicated whether a visitor can testify about things that happen in the report or it's all hearsay. At this point, I don't know why the court relied simply on that and simply on some of the statements and accusations of counsel. But unfortunately, because we didn't have an evidentiary hearing, it's one of the few pieces of evidence that we have that we can point to. There's obviously a lot more that we would have presented had we had a full hearing, but all we've got is the statements in the visitor's report, which in and of themselves indicate there's a lot of concern here, and in the deposition itself. And I will relate that one of the things that's the most stark in this case is if you look at the visitor's report and contrast it with the initial filings that were filed by counsel who had been retained for the respondent and counsel for Ms. Bradfield, and these were joint filings. The motion to dismiss and the reply, these are at pages 127 and 167 of the record. They're completely inconsistent with the statements that Dr. Henderson made to the court visitor, indicating that she had a cordial, warm relationship with her nephew. She didn't indicate in there that she was opposed to a conservatorship, but just said, I would like it to be somebody I know and I trust my nephew. Contrast that with a very short time later, as soon as counsel comes into place, they're accusing him, saying, well, this is not a cordial relationship. There's no basis whatsoever for a conservatorship. They're already inflammatory and seeking fees. I mean, that's, just one of the many things in this case that raises red flags. And I want to be clear, we're not saying that for certain there's any kind of exploitation going on here. We're just saying the trial court needed to get an opportunity to review that. Last point that I'll make, unless the court has questions about this and before I reserve time for rebuttal, one of the arguments that's been raised in this case is that if the petitioner wanted to challenge the POA, that he needed to file a separate kind of action to do that. We've obviously, in our briefing, raised a lot of points, cited statutes, cases from some other states that are applying similar provisions of code indicating otherwise. I've seen no contrary authority indicating otherwise. But I'll also add that the POA Act itself, this is in 1514-723, says that remedies under this part are not exclusive and do not abrogate any right or remedy under law. So even in that act, the General Assembly was making clear that it's not taking away other ways that parties can proceed. And of course, in a different part of the statute, 1510-302, regarding the court's jurisdiction and probate, a court has jurisdiction to take all actions necessary and proper to administer justice in matters before the court. So I submit there's no indication here that the court could not proceed in a conservatorship action where the ultimate relief sought was a conservatorship to look at the issues underlying the POA. So I'd like to reserve the remainder of my time for rebuttal.
Thank you, counsel.
Thank you, Your Honors. Matthew Zanatelli for Respondent Edna Henderson. I would like to have a warning at 7 minutes and a stop at 8 minutes so that my co-counsel can have some time to also argue for co-appellee Teresa Bradfield. Today, Your Honors, we're asking that you affirm the decision of the trial court. The first point that is very important is that while there is a hearing requirement, I believe and agree with counsel, inside of 1514-4061, if you read that statute, it says, upon the filing of a petition for conservatorship or other protective order, the court shall set a date for hearing. It doesn't actually say hold the hearing. The reason that that's so important is because when we walked into trial on August 31st, 2017, and I'm the only person here today who was counsel during that time period, we actually had 3 petitions before the court. We had the petition that Mr. Rennemeyer had filed, which was an amended petition, all the way back in December of 2016. And when we'd set hearing back in March of 2017 for a hearing all the way in August 31st of 2017, there was a 170-day period where we were operating under a petition that Mr. Rennemeyer had filed. At 4:53 p.m. the night before the hearing, all of a sudden a document is filed, and that document was titled Petitioner's Response to Objection to Petition, an amended petition for appointment of conservator for adult, and petition for provisional appointment of conservator, and motion to appoint special conservator. We'd been operating in a universe where we thought one thing was going to happen. Mr. Maurice Rennemeyer wanted to be the conservator for my client, Miss Edna Henderson, the respondent, and all of a sudden, 1 hour and 7 business minutes before the hearing, they completely pulled the plug out from under that petition, the one that my client and I had been taking discovery on, and completely supplanted it with, we don't know who's going to serve and the court needs to make findings. This interpretation of 1514-406, which is the hearing requirement statute, that we could go ahead and proceed for 9 months on one angle and then come in at the last minute, provides potentials for abuse for not only individuals, but for counsel.
Counsel, why wouldn't a request for a continuance have cured any such prejudice, if that's what you're claiming?
At this time, if you look at the petition that they were submitting, so my if you look at the transcript, I believe they go ahead and withdraw their petition, so they've got a brand-new petition. I don't believe that it was right for continuance, given all the discovery that we had done, and I don't remember them requesting a continuance.
No, it would be your client that would request a continuance if they're saying, we're surprised by this new filing. Why wouldn't a continuance cure any such prejudice?
We were ready to go at hearing that day, Your Honor, mainly because we were looking at what is provable under the conservatorship statute 15-14-401, which talks about the need for a conservator. We believe that there's a two-prong analysis. There's one that has to be done whether or not the respondent can receive and communicate information. The second is whether assets would be dissipated. And we were ready to go to trial on either one. The reason why I believe that we have to look back to 15-14-406 about this hearing requirement is that it says you have to have a valid petition before the court to get your hearing. Well, they withdrew, in my opinion, and in the transcript, page 9, lines 8 through 11, Mr. Rennemeyer in his petition, they were up, go ahead.
What if this court construes that as an amendment or modification of their petition where they're saying, I'm not seeking to serve in this capacity, but I want some third-party neutral to serve in that capacity? How do we analyze that?
So when a court is sitting in probate, they're operating under the Colorado Rules of Probate Procedure. We've just had a massive overhaul, but at the time we were under the old rules. If you look at CRPP 35B at the time, which is now the new CRPP 5B, it incorporates the rules of civil procedure into the rules of probate procedure when probate procedure doesn't have a specific act. When you take a look at such a massive undertaking and you would then incorporate CRPP 15, which talks about amendment of pleadings, if you're going to amend so late in the game, you need to do so with leave of the court and give us a chance to deal with that. And that was not the procedure that they took. Now, you can make amendments at trial to have evidence conform to the pleadings, the evidence taken conform to the pleadings, but because they just dismissed those and didn't proceed on the petitions, I believe that would have been improper.
Counsel, I'm a bit confused how you assert the dismissal when the petition for the appointment of a conservator was never removed from the court. The only change that was made, and you obviously considered it dramatic, was who the conservator was going to be. Why did you then resist the attempt to bifurcate the hearing and first decide if there is going to be a conservator, and then if there is, who that conservator is going to be? Wouldn't that have solved your problem?
Potentially, Your Honor. When I look at the requirements for what a petition is supposed to contain, and that's in 15-14-403 subsection 2 and subsection 3, in a valid petition for conservatorship, you're supposed to nominate an individual. It says, if the following must be asserted in a petition if known. Now, what they had done is we had a first petition which already had nominated the Deputy Public Administrator for Douglas County, Mr. Marco Chayette. And they found that there was some kind of conflict in the past between my client having retained his firm. Then they asked for Mr. Rennemeyer. And what continued to happen was we continued to have this rotating set of chairs that I feel, you go into court and you say, we'd been proceeding under what we had, a legal petition under what's required under the statute, and then we pull the chair out from underneath whoever we're supposed to serve, and now we're supposed to have a hearing where we don't know who the conservator may be.
Does that matter? If the respondent needs a conservator, if the court determines that need is there, does it really matter who that conservator is going to be at that point?
I believe it matters because I believe that there's it's right for abuse if you can just file a petition for conservatorship with someone and you don't put someone out there who's willing to go ahead and say, I am willing to take this on, assert this. The reason why is if you had a dispute, we have a father and son who own a business, and all of a sudden we get an offer to sell that business for 5 times what it's worth. And then all of a sudden that the son doesn't like the dad's answer. He says he won't sell. The son could file some kind of conservatorship petition, and then in order to kind of fish for discovery against dad, withdraw his name at the last second, but still have a hearing on dad's capacity. Dad better hope that he has no medical conditions, because if he does, those are going to come out at hearing and give the son leverage in the future. I don't think that since there was no evidence ever taken on whether or not Ms. Henderson required a conservator, then that won't be known at this time, Your Honor. I only have a little bit of time left, so I want to point out that number one, the visitor's report did state on page 58 of the trial record that they did not believe the proposed conservatorship was appropriate. B, there was a procedure under 15-14-716 where a power of attorney can be challenged and would have been more appropriate in this case, given that the power of attorney is the second thing filed. And finally, there was no duty, the way the appellant argues, that once a power was received to challenge it, they didn't need to challenge it. They talk in depth about a duty to make sure that there's someone to handle the money, but they received a power of attorney, and 15-14-719 and 720 relieve Mr. Rennemeyer of that duty. Thank you.
Thank you, counsel.
May it please the court, my name is Peter Bornstein, and I represent Teresa Bradfield, the agent under a power of attorney in this case. I'd like to use this time to do a little something, well, in reading the briefs and in preparing for oral argument, it became apparent to me that this case is really about whether the probate code sets up adjudicatory or accusatory procedures. The appellant in this case wants the code to operate as an accusatory type of law. The opening brief and the statements in the record uses the words over and over again, investigate. We want to use this procedure to investigate, or quote, to need to make sure his aunt's affairs are being managed properly, or there are red flags, let's investigate. It argues that there should be an initial determination to what Judge Nieto said. Can't we just determine initially whether she needs a conservator? We'll worry about the conservator later, but there's no basis, no grounds that are asserted in the record for why a conservator.
And why isn't the petition requesting that conservatorship part of that basis?
Because if we're talking about an adjudicatory procedure in which the proponent of the conservatorship must show by either a preponderance of the evidence or by clear and convincing evidence, then we have the duty to come forward with evidence. It relies on the petitioner.
They weren't given an opportunity to present that evidence. No hearing was held.
They were given an opportunity to present that evidence.
I don't see a transcript of a hearing.
Okay, well, no. But they, for example, they did not walk into court and say, we have an offer of proof. We have these witnesses, and as I understand it, they had no witnesses present to testify unless Mr. Rennemeyer was going to testify. They made no offer of proof, and they made no determination in their briefs that this is the evidence we would present, Your Honor, if we were given an opportunity to call our witnesses or to put on the evidence.
Counsel, when there's no hearing, at what point can they make an offer of proof?
Well,
You're not required to make an offer of proof before the court considers your petition. That's part of the evidentiary process.
If you go back and read the way the hearing began, it began with the counsel for Mr. Rennemeyer saying, we're not going to propose Mr. Rennemeyer anymore for this proceeding. The court was obviously taken aback by that announcement.
But isn't there a difference between, we're not going to propose him to serve as conservator versus we're not proposing to have him present any evidence? I mean, those are two totally different inquiries.
Well, let me go back. If this is an adjudicatory proceeding and the probate court operates that way, then it would be the proponent of the request for the conservatorship to say, hold on a second, we have evidence to present that would support the granting of a conservatorship. The record's devoid of that. absolutely devoid of that. It's all about, we need transparency, we need to have an investigator. The point of a neutral was not to have a neutral conservator, but it was to have somebody who would examine whether Dr. Henderson's finances were being handled properly. So I urge this court to consider that the issue of whether this is an adjudicatory or investigatory proceeding.
Well,
But then
counsel,
the-
let me ask you this.
Okay.
Would it have been proper for the probate court judge at that point to say, okay, petitioner, I understand that you're withdrawing yourself as a nominee for a conservator, and we don't have anyone else named in the petition, but we have this hearing scheduled. So let's proceed with the hearing. Call your first witness.
Yes.
But
I
did
think
that happen?
That did not
That did
happen
not
in the
happen.
record.
So there was no hearing. The court just, the way I understand it, the court said,
There was
Oh.
no evidence. I would agree. There was no evidence taken at the proceeding, yes. There were no exhibits offered at the proceeding, and there were no witnesses offered. Yes, the court could have said, call your first witness. But counsel for Mr. Rennemeyer went on and on and on about what he thought the court should do to become an investigatory agency. He did not go on and say, Your Honor, let me put on my first witness. Let me call so-and-so who's my first witness. Let me proceed with the hearing. So yes, the judge did not say, call your first witness. But yes, counsel never asked to call a witness or put on any evidence. But the second issue, I got 1 minute. The second issue that I see that needs to be grappled with a little bit with this case is whether the probate judges can impose procedural rules on the pleadings, given the nature of the probate code that we have there. The probate code has only bare bones rules for pleadings. And this case provides an opportunity, because this is what I think the judge did do, Judge Hawthorne, instead of the procedure that you're suggesting, which was an alternative to him. There was an opportunity for the probate judge to resolve issues of pleading procedures in the probate code. As my co-counsel talks about the need to, for example, ask for leave to amend. For example, not being allowed to file pleadings the night before a hearing. For example, whether there's a procedure to appoint a conservator under one statute and another procedure to examine whether a power of attorney under 1514-716 is being used properly or being abused.
Mr. Bornstein,
Yes.
or Bornstein, rather, I'm sorry. Your time has expired, so I don't want to interrupt you right in the middle of the sentence, but complete your sentence, please.
Okay. This case offers the chance for the court to tell probate judges that they can impose some reasonable procedural rules on the bare bones nature of pleading in probate proceedings. But finally, I'd just say I would urge the court to affirm the trial court's rulings in this case.
Thank you, sir.
Thank you.
Thank you, counsel. And Ms. Gomez, you have about 5 minutes and 41 seconds for rebuttal.
Thank you. I've got 4 points I'd like to make, time permitting. First, as to the only change at the beginning of the proceeding before the court was to who would act as the conservator, not anything regarding the need for a conservatorship. And I do want to make clear that after my client or his counsel indicated, I know my client no longer wants to serve as the conservator, would like to proceed on this bifurcated basis. Counsel for the respondent, after asked by the court, are you ready to proceed on that basis, said yes. This is page 13 of the transcript. So he could have asked for a continuance. He did not. He indicated he was ready to proceed as we were at that point in time. Second, on the issue of whether or not an oral modification would have been proper at that hearing under the rules of civil procedure, counsel for the respondent indicated, I think that was a new argument, but in the briefing, he indicated, well, under Rule of Civil Procedure 41, which is also incorporated under the probate code, he couldn't orally dismiss his petition at the hearing. So I submit that if either of those rules apply, then nothing could have happened, I suppose, to the petition at that point in time. On the third point, on the if we would have known, if you don't have the identity of who the conservator is going to be, they indicated that the statute provides that you should include certain information in your petition if known. I think that's what I was getting at. So who the conservator would be one of those things. So that if known indicates it's not mandatory. And as I indicated earlier, section 1514-4064 indicates that's the subsection dealing with the visitor's report and who the visitor is supposed to interview, and indicates they should interview the conservator if known. I mean, which again indicates like if a specific individual has been identified, that person should be interviewed. But there's nothing indicating that it has to be or that we could not proceed on this bifurcated basis. Last is to the question of why we didn't bring an offer of proof. I mean, at that point, we thought we were going to a hearing. And in fact, after we initially indicated that we wanted to proceed on this bifurcated basis, and both of the respondents' counsel and counsel for Ms. Bradfield stood up and kind of went on and on about different things. Counsel for Mr. Rennemeyer got up and said, can I respond? And the court said no. That was page 18 of the transcript. And then the court went on after that to basically say, I dismiss this petition. I find, these are the words of the court, that there is no basis in law or fact for the petitions. And then further down in the transcript said, the POA is sufficient to protect the respondent's interests. Again, there was at no point along the way that we were given an opportunity to present evidence at that, what was supposed to be a scheduled hearing. If the court doesn't have any further questions, then I'll close. We just ask the court to reverse for appropriate discovery, a hearing, and a decision on the merits of the issues properly pled in the case. Thank you.
Thank you. And the court thanks all counsel. Thank you for your excellent arguments. Those are going to be helpful to us in considering the merits of this case and reaching a decision. So the matter now will stand submitted, and an opinion will issue in due course. Thank you very much for being here today. And for our second case on our 2:30 docket, we have the case of People versus Verduzco Cervantes, case number 17CA2123. I see counsel are set up, and I presume you're ready to begin and have no questions?
No questions.
Okay. If anyone else has come in, I don't know or not, but if you have a phone, make sure it's turned off, please. Okay, counsel, I will remind you, I don't think it's necessary here, but we're live streaming, so if there's anything sensitive or confidential in this case, please be aware of that.
Good afternoon, Your Honors. May it please the Court. My name is Tara Yorfal, registration number 46193. I represent Ponciano Verduzco Cervantes. Mr. Verduzco sufficiently established that he would have pleaded guilty but for his attorney's deficient advice. More specifically, he would have taken the district attorney's generous plea offer of a sentence between 10 to 32 years had counsel adequately advised him on complicity, felony murder, and the advantages of the plea offer.
It's Ms. Jorfald, is that right?
Yes, Your
I wanna
Honor.
make sure. Didn't the trial court find that testimony from Mr. Verduzco Cervantes not credible?
And I think that's absolutely the issue here today for this court to decide, is what facts can the district court rely on in determining credibility? And I want to go through each of the cases, but I think the conclusion made by the U.S. Supreme Court and the state Supreme Court in this court is that in order to determine credibility, when it comes to the prejudice prong of Strickland, there has to be evidence, not a presumption, that conflicts with the defendant's statement. The district court here found 3 reasons why Mr. Verduzco's statement wasn't credible. The first was that Mr. Verduzco attended a preliminary hearing. The second was that his statement was based on hindsight, or in other words, it was self-serving. And third, that the public defender attempted to adequately advise him on these terms. None of these reasons conflict with Mr. Verduzco's statement that if he would have been advised properly about the plea and understood the consequences, that he would have determined to go to trial and risk a life sentence.
Counsel, doesn't the finding that the advice of the public defender was adequate, doesn't that controvert his statement that I didn't get advice, I didn't understand?
And, Your Honor, I would take dispute with the finding from the district court that the advice was adequate. It's clear that the advice was correct in its terms, that he tried to explain the terms of complicity and felony murder. But this has to be taken in context of the public defender's testimony in total, which the district court relied on, and also found that Mr. Verduzco did not understand the concepts of felony murder or complicity, that there was no rapport between Mr. Verduzco and his attorney, and there was no trust. And under this context, there wasn't an adequate understanding of the advice, and he wasn't able to do this. And in the public defender's own words, he got off the case before he could have the come to Jesus moment. He would have taken other steps to get another Spanish-speaking individual to discuss these terms because there was just no rapport. Under that circumstance, it could not be adequate advice. And just because he tried to explain these concepts does not meet the ABA standards or the standards in our cases that Mr. Verduzco is entitled to advice so that he can make a meaningful opportunity to take the plea. I take discrepancy to the point that how can you make a meaningful opportunity of plea when on the record you don't understand what felony murder is, you don't understand what complicity is, you can't talk about the facts with your attorney because you don't trust him, and that the shooting that occurred in this case by the co-defendant was an accident.
Well, doesn't the record show that Mr. Verduzco Cervantes actually himself, I think it was in the transcript, said and conceded that the public defender advised him about felony murder and about complicitory liability and advised him to accept the plea.
Well,
And he would not do that
well,
several times.
and yes, Your Honor, I would just add that Mr. Verduzco testified that the public defender attempted to discuss these things. But in the public defender's words that the court found credible, there was never a point where Mr. Verduzco understood these complex terms. And the record was very clear that Mr. Verduzco did not understand these terms. In addition,
Counsel, I'm confused. If the record shows that the advice is given and you concede that the advice was correct, all a defendant has to do is say, King's X, I don't understand, and that's sufficient?
Well, and here's the thing. There's more at the ABA standards that are put in the brief to just stating that, well, felony murder means this. It's adequately discussing it in a way that the defendant can understand so that he can make a meaningful opportunity to accept the plea. And it's not disputed in the record that that didn't happen, that he was processing these terms. And I would also cite to the Colorado Rules of Professional Conduct that when clients have a diminished capacity, such as language issues, that you need to spend more time with the defendant in this case. And I would remind the court that after the preliminary hearing, when this plea first came, the public defender spent 30 minutes with the defendant. One time in 30 minutes in a meeting that was cut short. 30 minutes is not sufficient time to explore these complex and takes that advice. And moreover, Mr. Verduzco had a Sixth Amendment right to counsel of choice. So when he was having these issues with counsel, he had the right to refer to Mr. Romero for a second opinion. And that's really the crux of this issue. What Mr. Young was attempting to do may have been sufficient, and our expert even said it may have been sufficient if he continued on. But instead, Mr. Verduzco exercised his Sixth Amendment right to counsel and said, I don't trust my attorney, we haven't built the rapport, I'm going to go to someone who speaks Spanish and that I identify with. And he had every right to rely on Mr. Romero's statement that he had a 50-50 chance to winning at trial, even though all of the evidence and everyone except maybe Mr. Romero realized that Mr. Verduzco had no chance of winning at trial except for maybe jury nullification. And I want to get back to the Strickland prejudice prong. I think this court really needs to go back and look at the fundamental fairness part of Strickland. Because the issue in Strickland, we all know the test, whether there's a reasonable probability the outcome would be different, right? But what is that based on? Is due process. The effective assistance of counsel is based on protecting a fundamental fair right to a fair trial. And so, and I'm going to quote the language from Strickland, the test for determining ineffectiveness is whether the outcome in this case was unreliable or fundamentally unfair because of a breakdown in the adversarial process. And that's exactly what we have happened in this case, right? Once Mr. Romero took over, he gave the case to an associate who had very, very little felony experience and had no experience trying, or no qualifications to try this case. He didn't file any motions in this case. Mr. Romero and Mr. Edstrom never once met with the client between the time that they entered their appearance and by the time this plea expired. All Mr. Verduzco had to rely on was a statement, I think you have a 50-50 chance of relying on this case. And when we consider prejudice, that is the fundamental inquiry that we have to make, is whether there's an adversarial process. And if you move into Lafler and Carmichael, I think the test gets even more nuanced. Taking a look at Carmichael, it's an objective evidence standard. It's not based on subjective impressions or opinions. You have to find that the evidence shows a conflict with the defendant's testimony. And I would also refer the court to the language in Cifuentes from this court that says credibility determinations not based on the traditional credibility factors, such as conflicting testimony, defendant's demeanor, a reputation for lying, are reviewed de novo, which is important, and not sufficient to overcome a defendant's claim of prejudice.
Counsel, what are we to make of the trial court's finding that Mr. Verduzco was, he was stubbornly rejecting a plea offer, regardless of the reason, that he would have refused to plead regardless of what advice was given to him, who gave that advice to him. The trial court was the one that observed him and had an opportunity to make that credibility, that judgment call. What are we to make of that?
Right, and a court does have the discretion to determine credibility, but there needs to be facts on the record. Oh, he was looking the other way, or there's conflicting testimony going on to support that. And Carmichael, pursuant to his adamance of innocence, Carmichael specifically says a defendant's declaration of innocence standing alone is not sufficient for the prejudice prong of Strickland.
Wasn't there evidence conflicting with his testimony And that evidence came from the public defender that said, no matter what I told him, he said, no, no, no. He was like a child saying, no, 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 and with no analysis behind that and no other kind of input. So there was evidence that was conflicting with Mr. Verduzco's testimony that he would have taken the plea offer had he been advised, and there was evidence supporting the trial court's credibility determination.
And I would absolutely disagree, because when Mr. Young, the public defender, states that Mr. Verduzco did not understand the legal concepts, we have to go back to the deficient performance standards. Did he have a meaningful opportunity to evaluate this plea? And if he can't understand the legal concepts, he's not there. Now, as a indigent defense attorney, we have a lot of clients that are difficult, and Mr. Young even testified to this, that he put an entire category of people that we have to advise that are like that. That does not change our obligations on how we explain to them, or that they are entitled to make a meaningful decision about the plea. On the contrary, we have to spend more time with them and not less. And I would also just remind the court that because of this lack of rapport and trust, of course, Mr. Verduzco is not going to talk to him about the case, facts of the case. He's going to say no, and he is entitled by the Sixth Amendment to go to Mr. Romero and rely on his opinion that you have a 50-50 chance. I would just argue where I started, that there's incredible amounts of objective corroborative evidence to meet the standard in Carmichael for prejudice. I don't think there's any dispute that it would have been rational to go to trial. I would just also point out that there were other counts that he risked a similar sentence as the plea, that the public defender had successfully made a deal with those other jurisdictions that they would be run concurrently. He had very little chance of winning. He was facing a life sentence where he had an offer between 10 to 34, where the co-defendant got 34 years. The public defender supported that Mr. Verduzco did not understand these terms, and private counsel advised him, come to trial and you'll have a 50-50 chance, and never once discussed with him the advantages of this plea. I would just ask the court to really concentrate on the prejudice prong of Strickland and the burden that the district court has to corroborate its credibility findings with facts that conflict. And I would argue here that there are no conflicts that fact, and that the court really needs to look at the fundamental fairness of the adversarial proceedings in this case, and how counsel deprived any adversarial proceedings in this case. And if there are no further questions, I would ask to reserve my remaining 2 minutes for rebuttal. Thank you.
Thank you.
May it please the court, I'm Patricia Van Horn, registration number 30,002, and I represent the people. The defendant was required to show both that his attorneys provided him with ineffective assistance and he was prejudiced. The record supports the trial court's finding that counsel, the PD, was effective. The PD explained how he tried over and over again to explain the concepts to the defendant, to discuss the evidence in the case with him, and the defendant just refused to listen to him, basically. He used
You don't dispute, though, that the advice he got from private counsel was deficient.
The trial court didn't make a finding on that. It just said, assuming that there was no prejudice. But Mr. Edstrom, I'm not going to speak to what Mr. Romero said. He didn't even, I think he testified, he didn't even view it as he had given the defendant any legal advice, Mr. Romero. Mr. Edstrom could not remember a lot of what he had done, but he said that the defendant was adamant he wanted to go to trial. He believed he would have discussed the plea agreement with him and tried to work out something less, a better deal for him. But he didn't remember because of the passage of time and the disappearance of his file. He no longer worked for the Romero law firm. He couldn't really remember what he had done. But the trial court did not make a finding on that. It just assumed that they were deficient. But the trial court said even if they were deficient, he was given advice by the PD, and he refused to take that competent advice. that's where the trial court found that wouldn't have made a difference.
But I guess I'm confused about how the trial could have relied on the advice given by the PDs when that relationship was so short and so fleeting, and even the PD himself said he would have done more had he remained on the case. I mean, how
That
could
was
he
a
not
6-month
suffer prejudice?
It was a 6-month relationship. The PD said he visited the defendant, I think, at least 5 times. He tried over and over again to discuss these concepts with the defendant. And I think that's what the trial court looked at, was you have this PD doing everything he can at this point, and the defendant just was refusing to listen, was being obstinate, and did not want to accept the plea, which was still open, by the way, when the new attorney came in, and the court asked, like, is there going to be a disposition? And counsel said no, and then the court said, the defendant realized this is the last day for this, and the defendant himself spoke up and said, yes, like, I realized this is it for me. And so I think what the court was looking at, also this credibility call, if you look at the defendant's testimony at the post-conviction hearing, it's internally inconsistent. It's also inconsistent with what the attorney said happened. He said, oh, they only met with me, the PD met with me once, maybe twice. Well, the record showed the PD met with him at least 5 times at the jail. And so some of it was just internally inconsistent. He admits at some point that the PD explained this to him and that he understood it, and then he later says, no, I didn't understand it. So those are the things I think the trial court could look at in determining his credibility, whether he would have, in fact, accepted the plea, or whether he understood it.
Remind me about the record. Did the PD actually testify that he didn't think that Mr. Verduzco ever understood the advice he was giving him about the felony murder and complicitory liability concepts, legal concepts?
Yes, Your Honor. He said words to that effect. I tried to get him to understand. I don't know that he ever understood. He would never even admit
He was there, or why he was there.
why I was there. He would admit it, he was at the house, but he wouldn't admit why he was at the house, like things that we had there was solid evidence on, he wouldn't admit, like I couldn't get anywhere with him because he was just refusing to admit things that were clear in the evidence.
Well, that's my point. I think in the testimony that I read, the PD said, I just couldn't get anywhere with him. I don't know that he ever said, I don't think he understood me.
He might have used those words like, he might have said something like, I don't know if he ever got it, or I don't think he ever, but I didn't read that as being that he didn't understand what he was saying. I read it more that he just was refusing to get it.
And he said, and the PD said, I don't think I was ever getting anywhere with him. What did that relate to, if you know? How did you take that?
I just think the PD thought that he was just not going to listen to what his advice was, and he did not want to acknowledge that he was even there, that he was involved in this at all. That no matter what he said, he couldn't get him to acknowledge the simple facts that there was clear evidence of, because we had witnesses who saw him there and knew he was there and why he was there. So that's the way I read it. And I would point out that the defense's own expert said that the PD was not ineffective at that hearing, too. So we have that.
Thank you.
The court has no further questions. I'd ask that the trial court's order be affirmed.
Thank you, counsel.
Thank you.
And Ms. Jorfold, you have 2 minutes for a rebuttal.
Thank you, Your Honor. I would first point out that the court should look at Exhibit B. Exhibit B that was submitted with the evidence shows the prison visits and the time that Mr. Young spent with Mr. Verduzco, as well as Mr. Edstrom's lack of visiting Mr. Verduzco until after the plea offer expired. I would just note that it was only about an hour and a half in the 6 months that Mr. Young represented him that he actually spent to him. These meetings were cut short. Mr. Young acknowledged that he had a very straightforward, candid style that didn't always come off well because he didn't coddle, and that at the end of the day, Mr. Verduzco, because of this, could not trust him. I think there's a big difference between our defense expert saying that Mr. Young was not ineffective because he was attempting to do the right things, and the ultimate inquiry that's at issue here is whether Mr. Verduzco was prejudiced. Because the issue is Mr. Young didn't finish. He did not get a chance to meaningfully explain these terms. Again, 30 minutes after the offer is not sufficient when you're having these problems that are undisputed about rapport and trust. And again, even if Mr. Young had said everything correctly and Mr. Verduzco understood, he had a right to get a second opinion under the Sixth Amendment. And when Mr. Romero told him that he had a chance at trial, he was entitled to rely on that opinion, as this Court of Appeals has said in Quinones, as this court, the State Supreme Court has said in Carmichael. If there's nothing further from this court, I would just ask the court to reverse the conviction and order the district court and the prosecution to reoffer the case, the plea offer. Thank you.
Thank you, counsel. And we thank you both for your arguments, and those arguments will be helpful to us in reaching a decision in this matter. And so the case will now stand submitted, and an opinion will issue in due course. Thank you very much. That concludes our docket for the day this afternoon, and the court will be in recess, and the bailiff may so announce. Thank you.
All rise. The court will be in recess, subject to call.